Okay, guys, we're gonna get started simply because we are live streaming tonight, so we do have probably several people coming online tonight. Um, so I'm sorry to abruptly interrupt you, but there'll be people watching us right now. So anyway, thanks for coming. This is actually our second meeting. Got a lot of really cool surveys coming back, and that really helped us determine what the guest speakers that are coming in the next few months. So based on your surveys in the last meeting, you're going to see some new printouts on your tables. And those are just things I've collected based on some of your other survey responses. One's on vision and the other's on driving, which kind of goes hand in hand. And in reading the statistics about adult drivers, if you haven't had that conversation with your parents yet, there's some great reminders if they are still driving and what you can be looking for on that. So those are all things you can take home tonight. The other one is on exercise and physical fitness. And it's also a great reminder as we get older, all of us, to keep moving. And our parents tend to live more sedentary lifestyles anyway, since arthritis is kicking in and joints hurt. So it's important wherever they are, wherever they're residing, to find out if they have programs and to encourage them to exercise. For example, my mom, I'm right in the middle of moving her into independent living, and they have an exercise program every morning. So I'm really, really excited about that too. So take those sheets home with you. Those are just things that I found based on, the surveys. And then if you're online too and would like a copy of what I just mentioned, you can go ahead and email me at cparks@sunrisefamily.org, or just come find me at church. And the same with what Dominic Pontello is about to talk to you about today. Let me know if there's anything that he has or anything else that you would like me to get to you, and I'm happy to do that. Also, if you haven't marked your calendars, our next meeting and guest speaker is on June 1st with all things Medicare and insurance related. So make sure you mark that one on your calendar. And then down the pipeline, I also have someone coming in about different senior living choices, independent, assisted, staying at home, things like that. I have a guest speaker. I just don't have her scheduled yet. So lots of really good things coming down the pipeline. So anyway, I would like to introduce Dominic Pontello, attorney at law, and he is going to fill our brains with information tonight about wills, trusts, estates, and everything else. So come on up.
Okay, well, thank you. My name is Dominic Pontello, and I am actually a member here at Sunrise. So now I know what Pastor Jim feels like. I'm usually just watching him up here. But yeah, I'm planning on giving a estate planning and elder law chat. Because I hopefully will just talk for about, I don't know, between 15, 20 minutes, and then answer questions. But I'm going to run through just a quick introduction of me, myself, and I, and then a quick run through of what your state-sponsored estate plan is, because if you haven't put an estate plan together, you still have one. It's just put in place by the state of Missouri under Missouri revised statutes. So I'll talk about that. And then I'll talk about why you want to create your own plan. Unless you're happy with the state's plan, then you can be done. But there are a lot of benefits to creating your own estate plan, and that's why the whole industry is here. Then I'm going to talk about the documents that are associated with an estate plan, what you need to have in place, and the benefits of that. And then I'm going to touch on the elder law side and why estate planning and elder law go hand in hand and are often talked about in the same sentence, even though they are distinct practice areas. But there's a reason that they go together. So anyway, like I said, my name is Dominic Pontello. I'm a member at Sunrise. Jennifer Pontello is my wife. We have two daughters, Elizabeth and Rachel. and we all come here on Sundays. Now, and a little bit about my career is I actually graduated from Mizzou Law in 2008. And at that time, the Great Recession was going, so there really wasn't any jobs. Actually, my first job out of law school was delivering pizzas for Pizza Hut. But then I went from that to started doing traffic tickets on my own, started running to municipal courts around town, met a lot of other lawyers, and then got my first associate job for a law firm downtown called Castle Law. They're no longer around, but when I worked there in 2009, 2010, he was the largest bankruptcy filer in St. Louis. So he was filing about 1,000 cases a year and working for associates. So I touched about 500 cases during the 2 years that I was there. So I decided, okay, I've pretty much seen all of this. I know how it goes. I'm going to start my own practice. So in 2011, I started Pontello Law, LLC, and primarily advertising myself as a bankruptcy lawyer. And I did a little bit of advertising, but a lot of word of mouth, and hustled and got busy enough that I hired my first associate, Isaac Bressler, in 2013. And through that practice, I started doing some litigation against debt collectors and companies that were harassing my clients. So I started doing litigation in what's called the consumer law realm, or consumer law. There's a law called the Fair Debt Collection Practices Act and the Telephone Consumer Protection Act. And my associate Ike and I started doing a lot of litigation, a lot of lawsuits. And he was like, why don't we start doing personal injury too? We're already suing companies, so we started doing personal injury work. And then we started getting into meeting other attorneys, and he came actually from an estate planning background. So we're like, okay, well, our clients are asking us, or finding us for all these other reasons, but then they're asking us to do wills and powers of attorneys. And let's do that. And so we've grown to the point, then in 2017, we partnered up. And so that's where we're at now with Pontello and Bressler LLC. It's two of us, and we have an associate. And now we're down on Boonslick in a little house there. If you're familiar with Main Street, it's the Ezra Overall House on Boonslick. So anyway, that's how I've gotten here. And so an easier way of saying all that kind of is I'm more of a general practice attorney at this point. So I do some of a lot of different things. And estate planning is one of them. And estate planning is something that everyone needs. Then when you get to the level of elder care and elder law, that's typically more of a specialist. So I have several other attorneys that actually specialize in elder law that I work with on various matters. So, I'm a good resource for basically any legal issue that you might have, because either I'm going to be able to help you or I'm going to find somebody to help you with it if it's something out of my wheelhouse. Okay. So your state-sponsored estate plan. So if you don't have anything in place, it's Missouri Revised Statute 474.010. So if anyone wants to go Google that, you can read it. It's very, very, very clear and in language that we can all understand from the 1800s. But essentially, it boils down to if you die without a will, they call it dying intestate, and these are called intestacy laws. So the state has set up a plan. When somebody dies and they haven't directed where their assets are going, the state tells you, okay, first, if there's no kids, if somebody's married, no children, everything goes to the surviving spouse. If someone was married with children and they die, half goes to the surviving spouse, plus an extra $20,000. They decided to give the spouse a little bit more. And then the other half goes to the surviving children. Then if some of the kids, and that's only if all of the kids are of the marriage. If there's other kids outside the marriage, then the surviving spouse gets their half, but not the extra $20,000, and then the rest gets divided amongst the kids. Then if there's no surviving spouse or no kids, then it starts going down to, or up, to parents, basically what they call next of kin. And it all trickles down to next of kin, okay? And then if there is no next of kin, then it just goes to the state's coffers, and they get to keep whatever assets you left behind when you passed. And that all goes through the probate process. So we've all, you've heard of the probate process, but all that is the court divvying up assets after someone passes away. And that's what the probate court does. And there's a lot of expenses involved with that. So one of the main reasons you do an estate plan is to avoid the time and expense of probate. And it's time and expense, and it's also, you have more control over where your assets go. But, you're really putting an estate plan together for your heirs, right? We're all going to be in the kingdom of heaven. Kind of what happens with your stuff afterwards doesn't really affect you much. So it's really, you're really doing it for the heirs, is typically why you're putting an estate plan together. And you're doing it, altruistically, because, people just fight. There ends up being a big argument. There ends up being siblings that don't talk to each other, and that's, in my opinion, really what you want to try to avoid. The time and cost and expense of a probate case, that kind of stinks. The lawyer makes more money, but really you're trying to get it so that it's clear. Your heirs know what you want to happen with your stuff, and they don't have to fight about it. And that's kind of the sad thing that I see doing some of this stuff and some probate work, is, it gets kind of nasty and people get, lose a relationship that they should not. So anyway, but a little bit about, but the expense and the time is real in probate. It's a minimum of 6 months to several years to go through a probate case. There's filing fees, there's attorney's fees, there's fees for the executor. A lot of times there's appraisal fees, there's publication fees. So, if you have a sizable estate, you're going to be running it, even a small estate, it's a few $1,000s to tens of thousands of dollars. So when you're talking about paying $2,000 for an estate plan, you are saving money in the long run. So there's a monetary benefit, and then there's the benefit to your heirs to have something in place so they know your wishes, and you avoid that fighting. So the documents that are associated with a typical estate plan, okay? Well, everyone's heard of a will. That is your basic estate planning document. But that's not avoiding probate, okay? Your will is for probate. The will is telling the probate court where you want the probate commissioner, the judge of the probate court, telling that judge what you want your assets, where you want them to go. So if your goal is to avoid probate, just doing a will is not enough. So that's typically why in a estate plan to avoid probate, you've got a trust, what's called a pour-over will, and I'll get into why it's called that, and then your powers of attorney. And typically it's 2 powers of attorney, your healthcare power of attorney and your financial. So that's your typical estate plan is really made up of those 4 documents. The trust, okay, that document is to avoid probate. And that document is, once you create a trust and you fund a trust, which is a second step that many people kind of forget about, it actually has to be funded to become its own entity. So the trust becomes its own bucket, it's a legal fiction. It's an entity that doesn't exist, but that's where you're putting your assets because the trust doesn't die. So the trust is still alive when you pass because you no longer own the property, the trust owns the property. And so how that trust gets distributed after you die is where you make your decisions. And then that's what the pour over will is for, is in case you forget things, it pours over all your excess assets that you've neglected or forgot about or got after creating this estate plan. It pours it into the trust. Again, you got to go through the probate process for that to happen, but you're probating much less this way, and therefore the time and expense is all much less. So that's your typical estate plan. Then there are ways to avoid probate as well outside of estate planning. It falls under the same umbrella, but without these documents, okay? So hopefully at this point, we've all heard of TOD. That's transferable on death. So anytime, now it's pretty much standard practice at the DMV if you go register, or you go get your title to your vehicle, you can put a TOD designation on that title. And that is, again, a document that avoids probate. So the heir can just take that document and the death certificate to the DMV and transfer title of that car, vehicle, boat, motorhome, whatever it is. No need for probate, no need for a will, no need for a trust. They can just take the title and the death certificate and go transfer that into their name. And so that's the same with the beneficiary designation that'll come on bank accounts, your checking account, your savings account, any mutual funds, brokerage accounts. Those all have beneficiary designations. Same with life insurance contracts. Most of these financial tools have that, and it's important to pick a beneficiary because then you're avoiding the whole probate process. Another way is what's called beneficiary deeds. So if your only asset really is a home, let's say you don't really have anything else, but you have this home, you can just hire somebody to file a beneficiary deed. You pick a beneficiary, you draft up that deed, you file it with the recorder of deeds, and it works just the same way as that TOD title on a car. You file a survivorship affidavit, and it transfers directly to the heir, avoiding the probate process. Another way that you can avoid probate is just what's called joint tenancies. And that's if you're a husband and wife and you buy a house in Missouri together, you're both on the deed as husband and wife, it's presumed that is a joint tenancy or jointly owned piece of property. And so the same thing is, it's like a built-in beneficiary deed. Each one of the joint owners is the beneficiary of the other as operation of law. So there's nothing further you have to do in that situation. So there's many ways to, quote, avoid probate. And that all, I guess, together can encompass someone's estate plan. So, you may end up having a trust, a pour over will, powers of attorneys, and deciding that you want your property deeded differently in a beneficiary deed. You might decide to title things in the name of the trust. These are all options, but the goal is the same: to minimize the cost and expense to your heirs, to direct where the assets go after you pass, and to avoid heirs fighting over your stuff. So then, so the cross, your estate planning and your elder law. The main reason these two go together is most of the time when you're thinking elder law, you're thinking government benefits and long-term care. And so that's why it's a specialty, because your normal trust will not work to do what's called a spend down, so that you truly no longer have control of an asset, and therefore you can qualify for certain government benefits to do whatever you need to do to, long-term care, assisted living, medical care, whatever the end goal is. That's going to be a separate plan to put in place than, okay, this is where I want my stuff to go and I want to avoid probate. This is where I want my stuff to go. I don't want my heirs to fight about it. I want to avoid probate. That's a different issue than I need to get on a government subsidy or government benefit for this. But they go hand in hand, because you might need a special trust in order to do that. So yeah, that's my chat. Any questions?
If you do have questions, since we're doing this live stream, I need you to stand up and face Dominic and talk into the microphone. So, yep, we've got questions. So,
How often do you need to change your will, and for what circumstances?
Really, there's no, like, I'm sure this will be the answer to 90% of your questions, but it depends. If your desires change, if the estate plan you set up no longer does what you want it to do, then you need to make amendments to it, or change it, or start a new one. If there's a new grandbaby that comes that you want something to go to, you're going to have to make an amendment. Now, on small stuff, most of what we were talking about is property that has a title to it. So a house, a car, bank accounts, insurance contracts, right? These have paper trails, okay? Your personal property, your jewelry, your heirlooms, okay? Those don't have titles. So it doesn't go through the same process. If you want them to go to someone specifically, that has to be written down in your estate, in your will, or in your trust, ideally in your trust. And usually it's just, I just do an addendum. So on my trust, I have a personal property addendum that is literally just lines on a piece of paper, and you write in your personal property and where you want it to go. And then you sign it and you date it. That's honestly good enough. So if that's what you're trying to do, if you bought a vacation home and you bought it in your name, okay, and you already have an estate and a trust set up, well, you got to do a little work to get that new piece of property into the trust, because it doesn't just happen automatically. So that's an instance where you might need some help, where you buy a new piece of property, but you buy it in your name because you're just, you're thinking like a normal person and you're signing it. You're not signing it as trustee of trust. Then you're going to need to do a quitclaim deed and put that from your name into the name of the trust. So anyway, I don't know if I answered your question, but it depends, essentially. Do you have, if anything more specific, or?
What if you change states?
If you change states, you should do a new estate plan. It's where you're domiciled. So yes, if you are living in Missouri, been here your whole life, have everything set up, but you go retire in Florida, you should go talk to a Florida estate planning attorney.
Okay, I have a couple online questions. I'm going to do the right
Sure.
thing and stand up here. Do wills expire? That's one question.
They do not. They get lost.
They get lost, but they do not expire.
They do not expire. No.
Okay.
As long, well, yes, they don't expire. They have to be in a certain format to be valid, but a valid will does not expire.
Okay, and then Anne has a question, and she's French, so sometimes her questions are a little different. So hopefully you understand. She says, so the addendum does not need to be notified. That's
Notarized.
okay.
Technically no, but it's always a good idea. I mean, that's just an extra layer of protection.
Okay.
Yeah.
Hello. So can people print things off online and do their own will and call it a day? Or does it have to be recorded with the county or state or what have you?
It does not need to be recorded. In the state of Missouri, you can print it off online, but if you sign it in front of one witness, it's not valid. You got to sign it in front of two witnesses and have it notarized. So yeah, I mean, just like you can change the oil on your car yourself, you can write a will yourself. Whether or not it's going to be done well and valid is a different question.
I have another question from myself. So I think I told you that my mom and I just went and saw someone Brian Quinn,
Yep.
an elder law attorney, specifically just to see if my mom qualified for World War II spousal benefits. We talked about a lot of stuff, and one was revocable trusts versus irrevocable trusts. And you mentioned earlier something about spend down. Can you touch the surface on that? Because that was a little overwhelming for me, and explain in case somebody is interested in an elder law attorney as well.
Sure. And it is confusing. So that is why you go to a specialist, because there are so many different options and they all have different reasons for being. But yeah, the basics are that a revocable trust means you can change it at any time during your lifetime. Any change you want to make, you can, again, you have the power of taking the pen to it, signing it. You can make any changes you want to it. And that's why it's revocable. You can revoke it at any time. You can change it at any time. You can amend it at any time. Irrevocable is just the opposite. It's a trust that's set. It's going to have specific ways that it can terminate, but you can't change that at any time during your life. And so when you're talking about spend downs and government benefits, it's really important because the government looks at a revocable trust as, well, you're just hiding your money. I mean, you can decide to change that at any time. It doesn't really mean anything to whatever agency you're talking to. So talking to the VA or Social Security Administration or Medicare, Medicaid, whatever agency you're talking to, their opinion is, well, no, that's you can change it at any time. So why are we going to give you this assistance when you can just go into that bucket and pull out stuff for yourself at any time? Okay, if it's irrevocable, you can't go to that bucket anytime. Then your chances of qualifying for these other benefits out of this other bucket are greatly increased. So that's the general framework, but there's very, very specific rules on each one. And then that's where the spend down phrase comes in, is there's what's called a look back period. So again, the government agency, the VA, whatever, says, oh, okay, it's an irrevocable trust now, but you just changed it, right? You told me I couldn't have an irrevocable trust, or a revocable trust, so I went and changed it to an irrevocable. But if you just did that yesterday, that's also not good enough. There's a period where it has to be in place for X amount of years. For some things, I've heard 5, for other things, 10. So that's the basic framework and the basic difference between irrevocable and revocable. Then there's also special needs trusts, spendthrift trusts. There's other kinds for specific purposes, and that's where you get into a specialization. Did that answer that?
Yeah, it was really overwhelming when I went in there.
I'm sure. Yeah,
So,
yeah, it's a lot.
does anybody else have any more questions?
Pretty easy question, I think. If a trust is already in place, it has a tax ID, right? Assigned to it?
No.
No?
It may or may not. You have to register that trust.
Yeah, so I think the one that I'm working with has tax ID. I mean, we have to file taxes in the name of the trust and every year, et cetera.
Yeah, well, if you've been filing taxes
Yeah.
in the name of the trust, then yes, it has a tax ID.
But
But if you're
we-
setting one up, it may or may not. You actually have to register it. Just like it's the same thing when somebody that starts a business, a lot of times they'll file an LLC, but then they won't file an EIN number. So that LLC does not have a tax ID yet because they haven't gone through all the steps.
Okay, but if we make significant changes to it, most likely it would have to be a new trust. Is that accurate? Like, for example, if you had a irrevocable trust and you wanted it to be revocable, do you close out one and you have to create a brand new one? How does that work?
It depends. So if it depends on what the irrevocable trust says. So if there's each trust is going to be different and drafted differently. So it depends on what it says on how to change it. If it legitimately has no, if there's no instruction in the document on how to change the document, then you will need to start over. Because that's the main point of that irrevocable trust, is it's hard to change. So your main difference between an irrevocable trust and a revocable trust is revocable trust, very easy to change, irrevocable trust, very hard to change.
Thank you.
What do you do if you do lose your will, a will?
You should draft a new one.
What if it's lost after the death?
Then you have died intestate, and the state has your estate plan for you.
My dad lives up in Maine, and we're going to talk with him when we visit about power of attorney. If he's going to assign that to someone, myself or my brother or both, do we have to be present with the lawyer, or can he just sign the paperwork? Is this something I need to encourage him to set up an appointment while we're there?
I mean, you really should ask the main attorney that.
Okay.
Yeah,
So
because
it's
that's going to
state-by-state.
be a state-by-state issue on what makes a valid power of attorney. In Missouri, you do not have to be present. You can give a power of attorney to whoever you want, but on the flip side of that here, whoever you're giving that power to, they don't have to take it either. But in Maine, yeah, it's going to be a different set of rules.
So speaking of power of attorneys, if you have two living parents and one might not be as healthy as the other, and then the healthier one might get sick, excuse me, then if you're the power of attorney, can you trump the one that might, excuse me, that might not be able to make good decisions, or not necessarily?
Yeah, not necessarily. There's a lot of spousal benefits, and one of them is the presumption that the spouse is going to be making decisions. Now, if there's a clear power of attorney in place that you are the power of attorney and the spouse is not, then I would say that power of attorney is going to trump the decision making of the spouse. But that would have to be clearly in place. If you're at the hospital and you don't have that document handy, they're going to listen to the spouse. Yeah.
Got another question?
If you're the executor for an estate or a will, as far as do you need to have access to the original signed notarized copy? Do you need to have just have a copy of the actual document, or do you need to always have the original?
You need, when you actually go to probate the case and be the executor, you need an actual signed notarized copy. If you're doing something outside of court, typically there's because a lot of times, sometimes trust documents can be 1,000 pages long, so you don't want to haul that to the bank to change an account or over to Edward Jones for whatever. So there's what's called a certificate of trust. But you do need to have a notarized original copy, typically. And every place is different. So when you go talk to somebody there, they might accept the photocopy. The court won't. The court wants a filed original copy.
Any other questions? Okay. I think what we'll do now, unless there's any other questions.
Well, I can touch on, actually,
Absolutely.
There's an issue that I didn't touch on that a lot of people do, worry about, and that's, debts. So, you can't pass along debts. So, heirs aren't going to inherit debts, okay? But, if you do have substantial debts out there, and you have assets, and you don't do a proper estate plan where where you avoid the probate process, part of that probate process is a 6-month waiting period to see if any creditors make a claim on the estate. So that's another reason that you want to be careful when thinking about this stuff, is if you have debts out there and you want to avoid them taking anything from the estate, the best thing to do is to just not have an estate. So if no probate estate is ever opened, creditors have nothing to come after. And then there's different rules on different types of debts. In my practice, I have a lot of people that are dealing with student loan debt. But if you're, there is what's called a death discharge for federal student loans. So that's just something that it takes. You write a discharge application and send it to the Department of Education, and that debt can't even make a claim on the estate. So your debts are also not just your assets, but your debts are also an issue when you're thinking about this stuff. And another little trap, so, avoiding probate process, if that's the name of the game and the main goal, then sometimes the TODs and the beneficiary deeds, they're great to have in place, but the unfortunate thing that can sometimes happen is what happens when the beneficiary predeceases you. So even if you have everything titled to go to somebody, you know, if they get into a car accident or whatever, and you survive them, then all of a sudden that asset has nowhere to go. So then you're back into probate court. So.
What about timeshares?
Don't buy them.
I know, but I just want to know. You're talking about debt that continues on.
Yes, it does not pass to your heirs. No, debts cannot pass to your heirs. No, no. Time. What's that?
Can you repeat the question so the people online can hear?
So if the timeshare is paid, then it's not a debt. It's an asset that you can pass along to your heirs. Yeah, you know, again, they don't have to take it though. And you don't, timeshares don't, they're a contract, so they're a little bit different, but yeah, it's an asset that you can pass along to your heirs. I would argue that's a debt, that would be a debt you're passing on to your heirs for the maintenance and whatever all the fees are. But no, debts do not pass on. You know, and actually, you know, some of these companies, they'll lie straight to your face and say that you know, this debt will, if you don't get these maintenance fees current, this will go to your heirs, and they're just lying. It's just not true.
Okay, so someone it has the beneficiary to their house, their deed is passed along to their children, but they've taken a loan on the house, so they owe more than the house is probably worth. You're saying that debt is not passed on to the beneficiary? 'Cause
Correct.
who's paying for the house?
Well, okay, so there's two things there. There's your personal obligation or the debt, and then there's the lien on the house. So if they want to keep the house, then they have to pay the lien, because that lien holder can still foreclose on the house, but they don't have to pay it.
Correct, you just wouldn't take it.
Well, no, the
Because
property.
you are getting the debt, basically. If you take if you take ownership of the house, you're gonna have to pay for it.
If you want to keep the house.
Correct.
Yes, because it's a lien.
And you can't sell it unless you pay the lien off.
Correct.
So you really are taking the debt on.
Well, no, because let's say they foreclose on the house, okay? Let's say you owe $200,000 and your house is only worth $100,000, okay? When they foreclose and they sell that house and they get $100,000, you still owe $100,000. That's a debt.
That's what you don't have
You
to pay.
can't pass that on to your kids.
Gotcha.
They get the house still gets foreclosed on, there's still a $100,000 deficiency, but they can't come after your heirs for it.
I see, yes.
Yeah.
Okay, thank you.
Any other questions? Well, I think what we'll do is we're going to have a little bit of time to talk around our tables and catch up from the last meeting. We found that really helpful with some fellowship time. So if you're at a table by yourself, join with someone else. But I'm also going to have Dominic come down, and then if you have some one-on-one questions for him,
Yeah.
we'll kind of do that too. If you want to ask him something personally or anything like that, or ask more about his services, things like that. So let's take maybe 10 minutes and catch up with what's going on, kind of like we did before. If this is your first time here, we found it really helpful to talk around the table about kind of what's going on in your lives too, because it is a support group and we want to make sure that we're supporting one another as well. So let's take them till about 7:30 and do that. And yes.
One last thing thank you very much, everyone. And then
Yeah.
one last thing for everybody online, well, and for you. I mean, my email's right there. If a question does pop up, feel free to just shoot me an email. I'll, if it's a quick answer, I'll just answer it. If it's something that I feel I'm not an expert on, I'll just point you in the right direction. So, thank you.
Yeah. Thank you for the online people watching as well.